In Arizona, real estate, the foundation of trust between a licensee and their client is built on the principle of disclosure. A licensee's obligation to disclose all known material facts that may affect the value, desirability, or consideration paid by any party is not merely an ethical expectation. It is a legal requirement, defined by both statute and administrative rule. This duty ensures that clients can make informed decisions based on full and accurate information, protecting both the consumer and the integrity of the real estate profession. Under ARS Section 32-2153, A3 and Commissioner's Rule, R4-2, 8-1101A, a real estate licensee must deal fairly and honestly with all parties and disclose any facts that materially affect a transaction. The Arizona courts have defined a material fact as any fact that a reasonable person would consider important when making a decision to buy, sell, or lease real property. This includes physical defects in a property, environmental hazards, zoning restrictions, or known title issues. In Hill v. Jones, 1986, the Arizona Court of Appeals held that sellers and their agents have a duty to disclose known termite damage to prospective buyers, establishing one of the state's most frequently cited precedents for material disclosure. Disclosure obligations apply equally to both buyer's agents and seller's agents. A listing agent must disclose all material facts known about the property to prospective buyers, even if those facts may negatively impact the sale. For example, if an agent knows that the home's roof has active leaks or that the property is within a floodplain, they must disclose that information. Similarly, a buyer's agent must disclose to their client any information known to them that may affect the client's decision, such as comparable sales, structural concerns, or nearby planned developments that could influence property value. Failure to do so may be considered negligence, misrepresentation, or even fraud under ARS Section 44-1522, the Arizona Consumer Fraud Act. A licensee's duty of disclosure extends beyond physical conditions to include transactional and financial details that could influence the outcome of the deal. For instance, if an agent learns that the buyer's financing is unstable or that a competing offer has been submitted, this information must be disclosed to the seller, as it directly affects consideration and decision-making. Conversely, if a buyer's agent becomes aware that the seller is facing foreclosure, that fact must be disclosed to the buyer if it could influence negotiation strategy or pricing. Consider this example. A licensee represents a buyer in purchasing a home and becomes aware through public records that the property has a recorded lien for unpaid contractor work. Even though the lien is not visible during the showing, the agent must disclose this information immediately. Similarly, if the buyer's agent learns that the seller accepted a backup offer at a higher price, the agent must disclose that fact to their client so the buyer can assess potential risks before proceeding with escrow. Disclosure also includes information affecting the consideration paid by any party, which refers to anything of value exchanged in a transaction, most commonly money, but also items such as services, trade-ins, or other property. For example, if a buyer offers a seller a lower purchase price in exchange for personal property, such as furniture or a boat, the licensee must ensure that all such arrangements are disclosed in writing within the purchase contract. This prevents disputes and ensures transparency in the transaction. Make sure that the lender is okay with the personal property in the contract. Some lenders will have you remove that and put it in a separate bill of sale. Under R4-28-1, 101B, a licensee must also disclose to all parties any information that could reasonably affect the transaction, even if that information is not directly requested. This rule aligns with the common law duty of honesty and full disclosure. The licensee cannot selectively disclose information that benefits one side while concealing details that might disadvantage their client. In Lombardo v. Albu, 1996, the Arizona Court of Appeals reinforced this obligation, stating that a fiduciary must disclose all material information which might affect the principal's decision. This means that even in limited representation or dual agency, a licensee must maintain impartiality and ensure all parties have access to relevant facts. However, not all information must be disclosed. Under ARS Section 322156, licensees are not required to disclose non-material information, such as whether a property was the site of a death, suicide, or illness, or if a person with a specific health condition occupied the home. The law specifically protects against discrimination by making such information non-material unless the condition physically impacts the property. This exemption protects both privacy and fairness, ensuring that transactions are focused on tangible property conditions, not stigma or perception. A practical illustration of this would be an agent representing a buyer who inquires whether anyone with a particular disease lived in the home. The agent should explain that such information is not considered material under ARS Section 322156, and that the law prohibits its disclosure. Instead, the agent can direct the client's attention to verifiable property conditions, such as inspections, environmental reports, and title history. This approach balances ethical responsibility with compliance under fair housing laws. Licensees must also disclose information about themselves when relevant to the transaction. If a licensee has a personal or financial interest in the property, such as being the owner, a partner in ownership, or a direct family member of the seller, they must disclose this relationship in writing before entering into the transaction, as required by R4-28-1101E. This avoids conflicts of interest and ensures that all parties understand the licensee's role. The Code of Ethics and Standards of Practice have many articles regarding disclosure review summary. The duty to disclose is one of the most fundamental responsibilities in Arizona real estate. Licensees must disclose all known material facts that could affect a client's decisions or the consideration paid by any party. This includes physical, financial, and transactional facts that are significant to a reasonable person. Under ARS Section 32-2153A3 and R4-28-1101, failure to disclose can result in license suspension or revocation. Landmark cases such as Hill v. Jones and Lombardo v. Albu emphasize that full transparency is essential for maintaining client trust and protecting the integrity of the transaction. Discussion. Why is disclosure of material facts so important in Arizona real estate? Answer. Because disclosure ensures that all parties make informed decisions and prevents fraud, misrepresentation, and legal disputes. What statute protects clients from concealment of known defects? Answer. ARS Section 32-2153A3 and the Hill v. Jones decision require that all known material defects be disclosed to clients. Can an agent disclose non-material facts, such as a previous occupant's illness? Answer. No. Under ARS Section 32-2156, such information is non-material and cannot be disclosed to avoid discriminatory implications. Closing remarks. Disclosure is not just a legal requirement. It is a reflection of integrity and professionalism. In every transaction, licensees are entrusted with information that can significantly influence decisions. The ability to identify and disclose material facts appropriately separates competent professionals from careless ones. By practicing transparency and honesty, Arizona real estate agents not only comply with the law, but also strengthen client relationships and uphold the ethical standards of the industry.